Welcome to r/RedditRevenge. This is a story of someone getting back at someone with revenge after being wronged. Thank you friends for subscribing to the channel and for so many likes. The first story. My business partner deleted me from our bank account and stopped paying. I was gonna sue him and won. The second story. Neighbor tried to steal part of my land, but he failed and he lost the court. And the first story is, can I sue my business partner in small claims court? A few years ago, I became a partial owner in an online business that my friend started. We are a multi-member LLC, taxed like a partnership in Oregon. I and one other partner own 20% each, and the guy who started the business owns 60%. For a number of reasons, I need to exit this business and move on with my life. We do not have an operating agreement. I know that's stupid. Please don't beat me up about it. I tried hard for a long time to get everyone to sign on to one, but it never got done. I gave notice to both partners that I intend to exit about 2 weeks ago. The minor partner has accepted that and we are working on a transition plan. The major partner so far has not responded to any communication. I assume he's frustrated and not ready to talk. All communication has been by email because we travel frequently and run the business remotely. Because he's a friend and I care about the success of the business, I plan to continue to try to engage him and structure my exit in a way that is fair to the business and my partners. My question. What do I need to be doing right now to make sure I cover all my own bases and do this right, considering that my partner is being unresponsive? Do I need to be sending certified mail or is email good enough? Email with red receipt? Something else? What kind of timeline should I be operating on? I have many more questions actually, but I'm trying not to think too far ahead and take this one step at a time. The research I've done so far leads me to believe that in Oregon, LLC members can remove themselves from a business 6 months after giving notice, but still retain economic interest in that business. Sorta like a last-ditch way to make an exit when agreements simply can't be reached otherwise. I've worked really hard on this business, and it's mildly successful. More than $100K annual profit. It's important to me that I protect my own rights, economically, while exiting the business in an upstanding way. There are probably a million ways this can go, and who knows what will happen next week, but what should my next steps be? Thanks in advance. P.S. I expect this to take some time to resolve, so I look forward to posting updates and continuing through the whole process here. Update. First, a quick update. I hired a non-litigation business attorney to help me figure out what my rights as an owner were. He was helpful, but that didn't go anywhere. My non-responsive partner finally contacted me after months of silent treatment while I continued to run the business, and the results were disappointing. A few weeks ago, he decided I'm no longer involved in the business, removed me from our bank account, stopped making distributions, and sent me a generous contract offering the opportunity to return my equity in exchange for not suing me for something. His threats were vague. Now on to the show. So now I've hired a litigation attorney who's the best and most expensive in town. I'll ultimately be following his advice, but I had an idea I thought I'd flesh out here before passing it by him in case it saves me some time. Read money, discussing hypotheticals with him. It is assumed that as long as my partner doesn't buy me out, I'm due to my pro rata share of distributions anytime they are made to other partners, and I'm not obligated to provide any further service to the business. Buyout talks are going nowhere right now, so my thought is, can I just wait for them to make a distribution to themselves and then sue them in small claims to recover my share? Seems like it could be an easy way to make myself whole one little bit at a time, and perhaps motivate him to have a more honest buyout discussion. It's unlikely my share of any distribution would be over the small claims cap, $10K. Is this a decent idea for a remedy? If so, who would I name as defendants? The company? My two partners? All the above? And how will I know if a distribution is made in the first place now that I've been removed from the bank account? I know I'm entitled to inspect company documents, but not sure what I would ask for in this situation, or if I could believe the accounting records that are sent. Update 2. I have a lawyer, 2 of them actually, and I listen to them and do as they tell me. I come here because I'm slightly neurotic, and being neurotic with your lawyer is not a financially sound practice. Today I have a brief update and another question. First, the update to entertain. For the last 8 months, my lawyer has been hounding the business's lawyer for the financial records I'm entitled to have access to, and we were either led on only to receive nothing after many promises to deliver, or stonewalled altogether. Finally, in November, we filed suit against the business in Big Boy Court to receive injunctive relief, requesting the business records and legal fees, which we believe were due under Oregon law. The registered agent, my business partner, evaded service until January. Then we received no answer to the suit until the day after we filed notice of intent to take default. The answer was filed by a different lawyer, same firm, denying all allegations and claiming I do not actually have interest in the business. They also got in touch. A third lawyer, again same firm, at the same time saying, "Let's talk. What do you want?" We said, "We want to be bought out." They asked, "Okay, how much?" We said, "Send the D records over so we can tell you." They said, "Okay, give us 2 days. We have them, but our admin needs to label them." They're running 2 different storylines, one officially in the lawsuit, and another in what at least felt like an attempt to negotiate. That was 2 weeks ago. We've been hounding them again, and are being stonewalled again. Based on the history of this case and my long-standing relationship with my partner, I'm no longer convinced they intend to negotiate at all, and our conversations so far are really just another attempt to delay. This morning it was uncovered that the business has altered some, official documents to be very much not in my favor. My lawyers are friggin' peeved, and we're scheduled to chat next week about potentially moving to a contingency agreement. Which brings me to my question. What do I need to think about before accepting a contingency agreement? I know the most basic things to think about. Ultimate value of case, cost to pursue, and contingency fee. But I really don't know anything else. Are there other factors to consider? I feel like being offered contingency is a godsend for most because it removes the uncertainty of the cost of litigation. That's enticing for me as well, but I'm also not destitute, and so far I've been pretty happy with how efficient my lawyers have operated. I feel like it's not a tremendous hardship for me to keep funding the operation, at least for now, and keep all the still uncertain spoils. Any advice on how to approach this? Update 3. Now the update. After spending months trying to peacefully resolve everything and getting stonewalled, we filed a document inspection lawsuit in November to compel my partner to produce all our agreements and financial documents so we could at least understand what the heck he was doing and to figure out just how bad he was screwing me. My lawyer, who's practiced for 30 plus years, said he's never had to file an inspection suit before because in Oregon it comes with attorney fees. No one allows themselves to be sued for that because it's a big liability. My partner dodged service for 2 months, so we weren't able to get the ball rolling until January. He had a lawyer this whole time, but they never agreed to accept service. And then more stonewalling. We ended up filing notice of intent to take default. The next day they filed an answer to the suit denying everything and countersuing for attorney fees, which apparently they can't actually get. In March, my lawyer's assistant was doing some routine research and just happened to find that the business filed amended documents with the state that completely omitted me as a member and owner. He was trying to erase me. My lawyer decided the best thing to do was to continue the inspection suit and file a new suit naming my partner personally for breach of fiduciary duty. That way, he could try to do as much useful discovery as possible under the inspection suit, where we could get the attorney fees back and use all that discovery again in the individual suit where we couldn't. This is also the point at which he offered to represent me on contingency, which was a huge relief for me because he's expensive and things were escalating. He also credited the fees I'd already paid towards future costs and expenses, which helped a lot. Even though the other side was making no effort to resolve the problem, that really felt like a positive turning point because I think getting a lawyer on contingency for a business and contract dispute is pretty unusual. I later learned my lawyer offered contingency because my partner pissed him off, and he wanted to keep turning the screws on him. He didn't want me to bail. I get the impression he's getting toward the end of his career, and just likes to work on the cases that interest him now. Fast forward a few months and we deposed my partner. That experience peeved my lawyer off even more. I wasn't there, but reading the transcript was both sad and hilarious. My lawyer said it was the 3rd most frustrating deposition he's ever taken. Oh well, guess you can't be first at everything. After the deposition, partner's attorney got in touch to offer a settlement. He was on his 3rd lawyer at this point, by the way. It was a terrible offer, so we said no thanks, but we'll do mediation if you want. They agreed, which is tragically comical to me. Mediation was my partner's idea that I agreed to before any of this insanity ever started. But he changed his mind at the last minute, and I never heard from him again. We spent a full day in mediation, and at the end accepted a mediated settlement when negotiations broke down. The settlement, once the contingency fee was subtracted, was not far from what I thought I was owed, so I was happy to accept it, and put an end to an emotionally draining 2-year saga. I often second-guessed myself throughout this process, and felt guilty for suing someone I once cared so much about. But really, he brought it upon himself. And I'm happy that I stood up for myself and am not spending the rest of my life asking, why did I let him get away with that? My ex-partner has a very strong cult of personality that served him well. He's very charming and can convince most people to do what he wants. I don't think anyone's ever stood up to him like that before, and it caught him flat-footed. The whole process was confusing because he never made a logical move, until he was truly backed into a corner and was facing trial. At every turn I wondered, is this a trap? Do they have some epic strategy I can't see? The longer things dragged on, the more I realized they didn't. There was no strategy beyond ignoring me until they couldn't anymore. Though my bank account is much healthier today, I have to say the money really rings hollow. I lost a friend and a partner in this debacle, but it was obvious I was going to lose that anyway, so better to have the money than not have it, I guess. And I'm very thankful I found the lawyer I did. I probably could not have sustained the fight all the way through trial without a contingency agreement. I could tell he really loved his job, and I think he's a little bummed we're not going to trial. The second story is, neighbor is trying to acquire a strip of my property through adverse possession. I purchased a house in Tennessee last June 2019. One of the main things I planned on doing was installing a privacy fence, since I'm next to a busy street, and there's a lot of foot traffic on the sidewalk. I got a fence contractor out in September to measure the corners of the lot. When I showed them where the plat on the official government records were, my neighbor came out and tried to tell me it was their portion of the lawn. Though I disagreed, I decided to wait for the fence and get a survey done. It took a lot longer to get a property surveyor than I originally expected, and finally got it finished in May. The survey showed that I was correct. After trying to disprove the survey and failing, my neighbor is suing for a 12 by 50 foot strip of land using adverse possession. Their thought is that since they've been caring for the land for 20 years that it's now theirs. They've not paid tax on the strip of land and have no structures on it. Edit. Regarding structures, it's tough to explain. Their house is behind mine and faces a different direction. They have a fence running out the side of their house that does enter my property. It does not block me from any sort of access to my land though. Back in 2014, the fence used to run all the way through my yard and bolt into the back of my house, so it's not like it was specifically built as a property marker either. They switched their argument against us, saying a fence was against city code. After that, they got a lawyer. So about 3 weeks ago, they admitted they knew where the property line was this whole time. The previous residents of my house owned the property for 10 years. They said the other neighbors I'm disputing with mowed it. I'm not sure who owned it before then. Update. We followed the original advice to get our title company to help with the case, but they ended up not helping. We had to hire a lawyer and the whole process took over 2 years due to COVID delays. Several of the cited cases were used in our case. Over 2 years ago, my household was served with an adverse possession claim by my neighbor. The dispute began 3 months after we purchased our home. We had to go to court, which ended up being 2+ years after being served. The judge ruled in our favor. Some details about the case. The neighbor was able to prove that they had mowed the piece of property for 20 years, which we did not and could not dispute. They had landscapers testify of the constant boundaries maintained in their contracts. Our verbal dispute over the property line occurred 19 years and 363 days after our neighbor moved into their property, meaning the 20-year adverse possession window would not work. The piece of property was considered relatively small because it's a part of a residential property. This proved to be the strongest element to win us the case. In Tennessee, there's a precedent that when the property is relatively small, the property cannot be claimed via adverse possession, if even structures are on the property. Lastly, while proving they had mowed the lawn, they could not prove that they had exclusive use over the land. This is one of the strict bright line tests of Tennessee adverse possession that the neighbor could not prove. I hope you love these stories. Subscribe, hit the like button, and turn on notifications. Thank you for watching.